Good afternoon, everyone. This hearing will come to order, and I want to thank our witness, Richard Cordray, the Director of Consumer Finance Protection Bureau, for appearing before our committee today. We very much look forward to your testimony. Today marks the committee's first official look at the work of the CFPB, specifically as that affects small businesses. The CFPB is drafting a number of regulations that will impose new requirements and compliance costs on broad segments of the U.S. economy. One of those regulations seeks to bring simplicity and transparency to real estate transactions. For many years, consumers, industry, and regulators have recognized that the mortgage disclosure forms required by the Truth in Lending Act and the Real Estate Settlement Procedures Act overlapped and are a source of confusion. The proposed rule, which is required by Dodd-Frank, or the Dodd-Frank Act, will integrate those disclosure forms. Integrating and simplifying the disclosures is a laudable goal, but these changes are going to affect small businesses. Many of my colleagues here today, including myself, question the wisdom of the Dodd-Frank Act and many of the provisions within it, including the creation of the CFPB. However, those issues aren't the subject of this hearing, but rather we're seeking to determine the extent to which the CFPB is complying with another law meant to protect small businesses, and that's the Regulatory Flexibility Act. Much of the public attention on this rulemaking has been focused on the disclosure forms that consumers receive when they are taking out home mortgage loans. Our committee is interested in how the regulations will affect small firms, those community banks, credit unions, mortgage brokers, mortgage companies, and settlement agents that will need to change business operations. They're going to have to upgrade software, retrain their employees to comply. And furthermore, the committee is looking at the quality of the CFPB's assessment of the likely impacts of the rule, as well as the alternatives being considered to lower costs for small firms. As the CFPB began developing this regulation, it determined that the changes would likely have a significant economic impact on a substantial number of small firms under the RFA. As a result, the CFPB convened a Small Business Advisory Review Panel to receive input from affected small businesses and completed an initial regulatory flexibility analysis, which was required by the RFA. On July 9, 2012, the CFPB posted the 1,100-page proposed rule on their website. And while the CFPB has followed the steps the RFA requires, there appears to be holes in the agency's assessment of the economic impact of the rule on small businesses and very little discussion of how the alternatives may reduce economic burdens. Even with the sluggish economy, the CFPB is expected to issue many more rules, and some as a direct mandate from the Dodd-Frank Act and others at its discretion. And despite our concerns with the latitude the CFPB has been granted, we hope they will honor the spirit and the letter of the RFA and become a model actor with respect to this law that seeks to protect small business firms so they can thrive, which is something our economy sorely needs. And we appreciate the Director's participation today on this oversight hearing. I now yield to Ranking Member Velasquez for her opening statement.
Thank you, Mr. Chairman. Since its enactment 2 years ago, Dodd-Frank has attracted significant attention from both critics and supporters. Of all the Act's provisions, it has been Title 10, which creates the Consumer Financial Protection Bureau, that has attracted the greatest amount of scrutiny. This new agency is responsible for protecting consumers from unfair, deceptive, and abusive financial products. Last July, the CFPB started operations, making this an opportune time to review how it is affecting American small businesses. Although the CFPB's primary role is to regulate financial products marketed to consumers, its rule also impacts small business owners. Small firms are major consumers of financial products, too. Nearly half use personal credit cards to finance their enterprises, while 1 in 5 utilize home equity loans for business purposes. It is clear that CFPB rules will influence small businesses seeking capital and credit. With the agency's broad responsibility, it is important that it balance the need to prevent abusive practices without adversely affecting the credit conditions facing small firms. It was for these very reasons that meaningful safeguards were incorporated into CFPB's enacting legislation. These efforts were designed to mitigate the potentially negative effects of this new agency on the small business community. For this reason, small community banks with assets of less than $10 billion were excluded from the reach of the agency, as were retailers and merchants. So too were businesses that are already subject to insurance or securities regulation at the state level. Some entire industries dominated by smaller entities are also excluded from CFPB authority, such as realtors and auto dealers. Clearly, lawmakers recognize that small businesses were not the cause of the financial crisis and should not bear the burden of new regulations. Beyond this exclusion, small businesses were given additional protections. CFPB must conduct small business advocacy review panels for certain rules, becoming only the third agency required to do so. Along with the Regulatory Flexibility Act safeguards, this will allow small firms' concerns about CFPB's regulation to be heard. Doing so can help reduce the impact on small firms while minimizing any additional cost of credit to them. The real issue before this committee is one of oversight. Our responsibility today is not to assume all arguments of ancient political battles, but to examine whether the agency is carrying out its mission in a way that safeguards consumers without overburdening small businesses. If done properly, this agency can make the entire financial system and the economy more stable without constricting our nation's entrepreneurs. With this in mind, it is not only the lingering memories of the financial crisis that make us remember why we created the CFPB in the first place. Almost every day we hear from a constituent about an erroneous credit report, pressure tactics from credit card companies, abusive payday loans, or coercive financing scams. As long as financial products are laden with fine print, scare tactics, and incoherent penalties, consumers will be unable to truly drive our economy forward. I want to thank Director Cordray for being here, and I look forward to his testimony. I yield back, Mr. Chairman.
Thank you, Nydia. Our witness, Richard Cordray, is the first director of the Consumer Financial Protection Bureau, and he was appointed to the position in January of 2012. And prior to becoming director, he led the CFPB's Enforcement Division. He's a native of Ohio, and Director Cordray has served the state of Ohio in several elected positions, which included Attorney General, Treasurer, the Franklin County Treasurer, and State Representative for the 33rd Ohio House District. Director Cordray has also appointed the first Solicitor General in Ohio's history. We're very pleased to have you today, and your entire written testimony will be entered in the record. So, please.
Thank you, Mr. Chairman. Here today. Thank you for turning on my microphone. I look forward to talking with you about the Consumer Financial Protection Bureau's work and how it does and does not affect small businesses. When I served as the Ohio Treasurer, I revived a small business lending program that pumped hundreds of millions of dollars into buying down the interest rate on small business loans to encourage job creation. From this experience of working closely with small businesses in Ohio, alongside the National Federation of Independent Businesses, I came to learn a great deal about how small businesses work, what conditions they need in order to grow, and their vital importance to local economies. I personally visited many small businesses, which are an important engine for our economy, as you know. It is critical for everyone in government to understand what is necessary for small businesses to grow and prosper in today's economy. The Consumer Bureau is responsible for administering and enforcing the laws that relate to the provision of financial products and services to consumers for personal or household use. Small community banks and credit unions and certain other small providers are an essential source of financing for many of these consumers. Since the Bureau was launched just over a year ago, we have designed a number of ways to invite small businesses to provide their opinions about our work. We believe good public policy means getting as much feedback as we can, and that is exactly what we do with owners and representatives of small providers from across the country. To this end, we are setting up advisory councils to help us focus on how our work affects the community banks and credit unions in particular. We have also created an Office of Community Banks and Credit Unions within our Office of External Affairs. And we have had hundreds of meetings and discussions thus far with small banks and credit unions reaching every state in the country. We have also been holding small business review panels during our rulemaking process. So far, we have convened 3 such panels, along with the Office for Advocacy of the SBA and the Office of Information and Regulatory Affairs within OMB, as required by law. These meetings consist of intensive, in-depth discussions about our upcoming rulemakings with small providers early in the process to help us shape our proposals around their specific input. This process makes us unique among the banking agencies as the only one that holds such panels. 15 to 20 people from small businesses and small nonprofit organizations may join us for each of these panels. They come from urban and rural areas, different segments of the market, and different parts of the country. We purposely seek this diversity to better inform the whole picture of the relevant marketplace throughout the United States. They get advance notice about the early shape of our proposed rules, and they come prepared to discuss with us how these proposals would affect their businesses both substantively and operationally. We come prepared to listen to their input, address their questions, and learn. During the panel meetings, our staff discuss the background, objectives, and elements of the proposed rule under consideration. The small businesses usually talk about the costs, operational changes, and other impacts from their perspective. They give their frank opinions, positive and negative, about the proposal and offer suggestions on how to improve it. It's a collaborative effort all around, and the participants have told us that they appreciate the care and effort involved. These small business review sessions, which typically last a full day, have proven to be valuable to us. From the panel we held on proposed changes to the federally required mortgage disclosure forms, we learned, for example, that we needed to provide more detailed guidance to accompany the rule, which smaller providers viewed as helpful for their compliance efforts. Indeed, the small businesses told us that smaller settlement agents can lose a half hour per closing because they struggle to understand various issues with the current rules, and that's multiplied across millions of real estate closings. So we took that insight in drafting our proposal, which now contains extensive commentary that details precisely how to complete the proposed forms. It also includes samples of completed forms. This extra material has become more specific in order to make it easier to implement the rules once they are adopted. These panels and the detailed reports they write afterward have played an important part in these rulemakings. As in everything we do, we are open to feedback and will continue to refine our processes as we gain more experience. The bottom line is we are committed to include small businesses in our rulemaking and to shape our proposals based on their input. Let me close by saying that at the Consumer Bureau we believe in smart regulation. Although we are seeking to streamline and simplify rules, when we are told it would be helpful to provide more detail and more specifics, which is a suggestion we hear often from industry, we take that into account. We recognize that while we are issuing regulations to protect consumers, we are also issuing regulations to provide certainty to financial providers. Because we believe in the free enterprise system, we want to see honest, fair consumer financial businesses compete and thrive. Clear rules of the road that reflect the input of small providers help achieve that goal that is good for consumers and for the overall economy. Thank you. I look forward to your questions.
Thank you very much. I appreciate the testimony. We'll start out, Alan.
Thank you, Mr. Chairman and Madam Ranking Member. Thank you, Mr. Corderay, for being here today. And you're right, I was not here when Dodd-Frank was passed, and we're not going back to do a history lesson. We're going to look at the law of unintended consequences. Okay. One of the things in your written testimony talks about tight statutory deadlines. And I guess that's part of the law that was written in there. But my concern is that when I look at these small business advocacy panels that you have, review panels, that some of the individuals, these small entity representatives, were only notified, a couple of weeks before, and then yet we're asking for written input back a week later. Do you really feel, when you look at the economic impact of some of these rules and regulations, that that really is enough time for them to operate under? And do you think that you can come back to us and ask for, extended times if that does constrain you?
So thank you, Congressman. It's actually a very good question, and it is part of the landscape that we're dealing with over this first year in particular. We have some very tight statutory deadlines. We have a number of mortgage rules that are required to be in place by January. If they're not in place, I would note that there are statutory provisions that kick in of their own accord. So whether we write the rules or not, things are going to change according to what Congress has done. But writing the rules allows us to get a lot of input from people and perhaps soften or change or modify some of the provisions. So I think for the most part, a lot of industry is very supportive of us meeting our deadlines and being tight on that.
But you think the 1 week gives them really enough time to look at this?
So as to the balance of your question, in retrospect, we would have preferred to have had more time to prepare the panels. And we will in the future have more time to prepare the panels. I will say it's a self-selected group. There's 15 or 20 people from around the country who very much wanted to participate in this process, were picked out, in part by themselves and organizations that sponsored them. So they had a real incentive to be involved in the process. They did complain to us, or they did comment that it was a very quick time frame, and that is what we're living under. In the future, it'll be nice to have more time for that, and we expect to allow more time.
So is there a way that we can come back and say, if we don't get this thing right, we need more time to get it right instead of rushing into it? One of the things in the military, we said you always train to a standard, not to a time. So I want to make sure that we get the standard correct and not just worry about the time. I mean, do you feel that you have the flexibility to come back and ask for more time if the industry members ask for that?
By the way, I noticed your Army background. We have some real leaders at the Bureau who have Army background, and they keep us pretty straight.
Navy.
But what I would say is we'll always be subject to any dictates that Congress lays down for us. If Congress decides we should have more time, we'll be glad to take more time. If Congress wants us to be faster, we'll be faster. We're a law enforcement agency, and what you tell us to do is what we will do.
Okay. The second question, if there are other agencies outside of CFPB that provide rules or regulations, are those rules and regulations also going to go through the same type of advocacy review panels, or will they be able to slip under the radar screen and get implemented without having that process?
So the law as it currently stands, the small business review panels, which we've actually found to be quite valuable, they only apply in the Federal Government to EPA, to OSHA, and now to the CFPB. They don't apply to other financial regulators. That was the wisdom of Congress, and that's the statute that we're enforcing. So the answer to your question is, other than us, EPA and OSHA, that process otherwise does not apply to the rest of the Federal Government.
Do you think that that's something where we should go back and look at amending in case you have Federal Reserve or someone else that tries to, send in a rule and regulation that we need to make sure that they have to go through the exact same process?
So I find that I have my hands full trying to run my own new agency. I typically don't go out of my way to offer suggestions to Congress about how other agencies can be governed. They can certainly offer that perspective themselves. I don't really have a position on that, I guess.
But I guess the question I'm asking in the last 40 seconds is, do you want to make sure that other Federal Government agencies cannot slip under the radar screen and implement rules and regulations that don't end up going through your small business advocacy review panels? And the next thing you know, this is, surprise, surprise, here's something else. And once again, the unintended consequences, the economic impact is exacerbated even more.
So again, I would defer to Congress. I would leave it to them. I would say that we are working hard to collaborate closely with our fellow banking agencies and other agencies and departments of the Federal Government and state government and local government. We think that we will do our work better if we're in partnership with others and that we're on the same page, so that the kind of small businesses you all are looking out for aren't confused because different people come at them from different perspectives. I do think that's quite important.
Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Chairman. Mr. Cordray, in the last Congress, the House passed the Medical Debt Relief Act, requiring paid or settled medical debt to be removed from credit report within 45 days. That bill directly addressed the negative impact such information has on a consumer's credit score. With your recent announcement that the CFPB will regulate credit bureaus, do you plan to address how medical debt is treated on credit reports?
So that's a very interesting question. It's something we've been grappling with at the Bureau, not only as medical debt affects credit reporting bureaus, as your question goes to, but also as it affects debt collection, which intersects obviously with credit bureaus. That's often the way things end up getting reported to credit bureaus. We have found medical debt is a peculiarly difficult challenge, because it is hard at times to define when a debt begins in the medical debt realm. You'll go to your doctor and you'll receive services, and it may be understood by the doctor's office you don't necessarily pay on the spot. They will bill you later. When do you actually owe the debt? Is it as soon as services are rendered, or is it after the first round of billing is done? There's often disputes between insurance companies as to what they cover and don't cover, so you can't even, we may not, I know for my family, we may not know for a period of months exactly whether we owe a $10 copay or whether we owe, $250 or whatever it is. So whether you would consider that a debt or whether it's still a disputed item not yet firmed up, it's a hard issue. So what I would say is this. We have announced recently the finalization of our larger participant rule. This is a special process that's laid upon us if we're going to be overseeing financial providers that are not banks in new realms such as credit reporting. We are going to be overseeing and supervising the larger participants in the credit reporting industry. That will cover about 30 or so credit reporting companies, including the 3 very largest that are the ones people are most familiar with, that keep consumer files on millions and millions of Americans. We will be overseeing all of their approach to this, including to medical debt. We are in the process of working through issues of medical debt as it relates to our now what will soon be our supervisory coverage of debt collectors. We'll continue to work through those issues. It is a sensitive spot because I know from my experience at the local level, I collected real estate taxes at one time, and one of the big issues that created delinquency for people was illness, injury, death in the family, and the debts that piled up around that often put people into default or foreclosure. So it's an issue we're very concerned about. We will be looking at the credit reporting bureaus with respect to that debt and all debt.
Thank you. One of the key responsibilities given to the CFPB is the supervision of non-banks. What role can these non-bank entities play in providing alternative sources of capital for consumers and small businesses?
So I think we've seen in a number of markets that non-bank firms have been providing significant access to capital for individual and family consumers. We saw that in the mortgage market significantly before the mortgage breakdown and financial meltdown of 2007, 2008. Tremendous amount of financed mortgages that did not go through any kind of bank or credit union or thrift or any kind of chartered institution. And one of the problems in that market was that some parts of it were regulated and some parts of it were not regulated. And whatever your regime is, whether you think regulation can be a good thing or a bad thing, whether it's good in these circumstances, not in those circumstances, whatever your view is, the notion you would regulate part of a market and leave part of it unregulated, that doesn't work. I mean, that just doesn't work. It's unfair advantages for some and disadvantages for others. It tends to reward the irresponsible who don't bear the same costs as the responsible. That was part of the problem in the mortgage market. It's part of what was changed, and I think much for the better, under Dodd-Frank. So we are now, for example, we're overseeing and enforcing the law against both bank and non-bank mortgage originators and mortgage servicers. Mortgage servicers, all of your office staff and you could tell me, has been a significant source of problems for individuals in districts across this country. In other markets as well, the market for short-term small dollar loans, which is a difficult market, one that is supplied often these days by payday lenders or other providers, maybe pawnbrokers, maybe rent-to-own, other things. It's a market where there's a lot of concern about how consumers are treated. On the other hand, it's a market where consumers have a demand for that credit. So that's another area where we will cover both bank and non-bank sides of that, and I think that's helpful. But there's no question that the banking system alone has not provided access to credit that satisfies the needs of the American public. We have estimates of 80 to 90 million people who are either not banked at all or they have a bank account, but they use many other services outside the banking system, often to meet their needs. This Bureau cares about all of those consumers as well. It's not just if you're in the banking system or get yourself into the banking system. It's also how can we meet your needs in that space with prepaid cards and other things, and it's very fast evolving, so it's hard for us to keep up with it.
Can you talk to us about the Memorandum of Understanding that the CFPB signed with the FTC to deal with jurisdictional overlap between the agencies? Will this be enough to limit bureaucratic duplication, or do you think that there might be something else that needs to happen?
So what you're inquiring about is the fact that we now have authority over many non-bank providers of financial products and services, but the Federal Trade Commission, Congress decided to retain overlapping jurisdiction of the FTC in many of these areas. They typically don't have jurisdiction over banks, but they do over non-banks. So Congress specified that we needed to work out a memorandum of understanding between us and the FTC as to how we would jointly use our combined resources to address problems in that space. We have worked very closely with the FTC. They've been a great partner. Unusual among Federal agencies from what I know from over the years. They have really reached out and worked with us. We did reach a memorandum of understanding by July, which was a deadline for us doing so, and we've been working with them on working groups in a number of different issues together very productively. The other actors that have some role in the same space are state regulators and state attorneys general. We've also been trying to forge a constructive partnership with them. Ultimately, what you would want, I think, is for all of us in the space who do have the ability to oversee and crack down on illegal practices by non-bank providers, that we coordinate our efforts, we coordinate our resources, and we create the best bang for the buck for consumers, and also in ways that don't do stupid things by double teaming or duplicating. There's plenty enough for us to do without us trying to do the same things as one another. But that requires a lot of communication.
On my last question, because we basically, this is the Small Business Committee, and a lot of concerns have been raised by small firms who are concerned that they will be subject to the CFPB oversight for financial transactions. Mm-hmm. So my question to you is, will your agency attempt to exercise oversight over financial products when no consumer is involved?
I don't think that we have the authority to be involved in a financial product where no consumer is involved. Our statute's pretty clear that we're supposed to be, as a general matter, there may be some specific provisions in the statute that are different from that. But as a general matter, our authority is over consumer financial products and services defined as credit and financial products for individuals, households, for their families, for their personal purposes, not business credit, not business-to-business dealings. Again, there are a few odds and ends in our statute where that somehow relates, but that's in general not our field. Yes.
Thank you. Thank you, Mr. Chairman.
Scott.
Thank you, Mr. Chairman. Thank you, Mr. Cordray, for being here today. Would like to be able to explore just a couple issues with you. Recently, you were testifying today that the CFPB is taking some steps to be able to mitigate some of the criticism that you regard in some of the, is it the TILA-RESPA rule, is that how it's referred to?
Yes. Mm-hmm.
And it being 1,099 pages, and you put up a blog post that it was actually only 400 and some odd pages, and the rest was regulatory, just to be able to get some definitions out. Did you get feedback, and can you understand that for small businesses, when we start issuing 400 new pages of regulatory requirements, that this actually becomes a burden?
Let me say several things. First of all, to sort of correct the record, there's about 200 pages of that is the rule. There are about 200 pages of guidance that we included in particular in response to input from small providers who told us that absent guidance and clarification on things, they found that they lost time trying to figure things out, trying to interpret it. That's what I referred to, up to half an hour per real estate closing multiplied by millions of closings. So what they told us, and it's kind of counterintuitive for me, I mean, I'd prefer to have short, simple rules, but these are complicated matters. They have asked for more detail, more specificity, which ultimately means more pages, in order that they won't have lots of questions afterwards. And by the way, if we issued a short rule, simple rule, but left things vague, what happens is everything still has to be figured out. It gets worked out on the back end. It often involves litigation. It involves going into court to get a court to tell you what it actually means. That's expensive for businesses. It obviously takes time. There's uncertainty all during that time. A comparison I would make is the U.S. Constitution. It's a simple, very elegant document. For 200 years, courts have been construing what it means, and there's a huge amount of pages now that have been generated by that. What industry has told us, again, it was contrary to my initial instinct on this, was if they can have more specificity and clarity up front, then there'll be less to argue about afterwards, less litigation, and also more certainty for them how to proceed. So, again, optically, I don't like the look of a longer rule, but they have told us in some respects that makes their work easier.
And with respect to your statements, did you do a cost-benefit analysis on this?
We are required by our statute to do an analysis of the burdens, impacts, and benefits of
What did that show?
Any rule. Beg your pardon?
Are you doing that now?
We have been doing that. We have to do that at the proposal stage, so we have done that. We have to do that as we go, and we absorb.
Just out of curiosity, what are those costs going to be?
Well, I think the costs are the ones that people told us about. First of all, there's always a transitional cost with any change, even when you streamline things.
Do you have a dollar amount?
Which is, well, there's a lot of analysis provided in the rule. I would hesitate to summarize, what is, as you noted,
Ballpark?
hundreds of pages. Well, there are costs that are implementation costs of making a transition.
Right.
And then as we go,
ballpark figure.
important to recognize here, as we go, since we will have integrated these two forms as Congress has been wanting to do for 20 years and nobody's succeeded in doing it yet, that will mean less cost per individual real estate
So you
closing.
don't have an actual dollar number, a vague dollar number?
There are dollar numbers provided. Again,
That's what I was asking.
Okay. I can refer you to our rule, and you can, your staff, there's different dollar figures for different kinds of
Did you
providers.
maybe get us those dollar figures?
Beg your pardon?
Did you get us? I just curious.
Sure.
In terms of the
But what I wanted to note was over time, this is going to save money.
You're 101 million. Does that sound familiar?
That's a potential figure, depending on what assumptions you're making about who uses vendors and who does things on their own. But again, there's going to be a savings, sir. It's important to realize.
I'd like to be able. I mean,
by integrating these forms.
Here,
Okay.
at the beginning of your statement, you'd made the statement, critical for people in government to know what makes small business grow. And you
Yes.
talked about access to capital. If those dollars are being spent more and more on regulatory compliance, $101 million, is that draining money out of resources that can be applied to be able to grow jobs, to be able to get people back to work and get this economy moving?
Okay. So we're talking here about a multi-trillion-dollar market for real estate transactions.
My world,
And we're,
millions of big dollars.
I understand. But it's not like there's $1 million falling on each business. That's not what we're talking about here. And there's going to be savings in each real estate settlement closing, each one over time, that will pile up year by year by millions of transactions, and that needs to be taken into account as well.
Actually, we received comment, and I believe you probably have the written testimony as well from the realtors, that they are concerned about this rule, who's going to have to be filling out the forms, what some of those costs are actually going to be, and I think they're deeply questioning a lot of those actual cost estimates that are being taken so for granted by the administration.
Well, we have met with them, and we welcome their input, and at this point, this is at a proposal stage. It's not yet a final rule. And so everybody's going to have a chance, including what I hear today, but also as we go through the notice and comment process, to give us their input, and we will take that into account on the final rule, including from the realtors, settlement agents, all of the people involved with these transactions. Yes, sir.
You know,
Sure.
With your permission, Mr. Chairman, just okay. I yield back. Thank you.
Thank you.
Before I turn to Bill, we do have a series of votes coming up.
Okay.
And we're going to stay. We'll stay here for the first 10 minutes after they are called. But I hate to keep you through that series. So we may, if anybody's got questions that can be submitted, and then you give us answers, because I know I do. We'll make that a part of the record.
I'm at your service.
Bill.
Thank you, Mr. Chairman. Thanks, Mr. Cordry, for coming over to testify today. When you talk about small business, how do you define that term for purposes of inclusion in the small business advisory groups?
So, again, that's another interesting question. The term small business is somewhat in the eye of the beholder. It's defined differently, often market by market. So what is a small business in the aerospace industry would look very different from what's a small business in the hardware business, for example. The Small Business Administration has a working definition that they apply as a rough cut for many markets, that if you have revenues of $7 million or less, that's a small business. I can imagine markets where that would be a very large business, but that's one cut on it. It is likely for us going to be something that we'll have to define, taking into account the size of markets. I think the assets of a bank, for example, would be larger than the assets of many retail businesses. So it's very contextual, but that is one definition to begin from and think about, and then work from that. So that is one of the things we've taken into account.
How did you define it for purposes of the groups that you assembled?
So for us, it's as laid out in the Regulatory Flexibility Act and the SBREFA panels, the Small Business Review panels, which, as I've said, have been used previously by EPA and by OSHA, who are required by law to use them. We're the first banking agency of any kind that's been required to use this process. And the other thing for us is we do have this other hurdle we jump through before we can supervise non-bank firms in some of these other markets besides the mortgage and student loan and payday lending markets, and we have to define who are larger participants. And there, too, we started off by taking as one of the factors we considered this SBA definition of a small business at $7 million or more, definition that's under review, by the way, by them right now. But there are some industries where that makes sense and some industries where that's probably well off the mark.
Yeah, it's been my experience that settlement agents tend to be relatively small businesses, a couple of people. Mortgage brokers in small communities tend to be a couple of people.
Yes.
So that puts, I think, as some of my colleagues were pointing out, some real burden on them in terms of compliance. I see in your testimony that you are considering potentially not requiring electronic retention of records and allowing paper retention for smaller businesses. Are you seeing any development by other entrepreneurs of software for this industry that is graded, if you will, from the couple of person business up to the 50-person business?
That is happening. That's obviously a tremendous business opportunity. Part of it is that 30 years ago there was very little computer involvement. I mean, going back to my undergraduate days, where to do anything on the computer, you went across campus, it was a garage-sized thing, and you put in your cards, and it took several hours. But now computers obviously are more and more integrating workplaces everywhere, and this is a vendor opportunity. So that is developing. But we have, in response to the input we got from small providers, some of whom haven't gotten to that point and may never get to that point. They've been in business 20, 25 years. It's working for them. They don't really see the need to do the expense of upgrading computer services. We have put into our proposal to consider exempting them from this electronic standard format, which we otherwise prefer because it's going to make things very comparable. But that may not make sense for all providers, and that's something we've listened to them on, heard from them on, and we're going to consider that as we finalize a proposal.
I also noted that you said that in some of instances, the small businesses requested that you expand on the regulatory statements.
Yeah.
And that was because they felt that with greater clarity, there would be less litigation and less confusion. After you did the expansion, what was the response of those small businesses to the additional information you provided?
I think in general, there was appreciation that we heard from them, listened to them, and responded to them. Now, of course, people have various disagreements about the substance of what's in there, whether we took their proposal or the escrow association's proposal or the credit union's proposal or something else. There's obviously always room for substantive disagreements. But I think they like the fact that we heard their suggestion to include more guidance. Again, every problem we can solve for them without making them sort of solve it on their own, which not only involves uncertainty about whether they're getting it right. They can be sued under the Truth in Lending Act if they don't get things right. That can involve expense, or they may feel the need to consult lawyers, which is expensive, not something small businesses want to have to do if they can avoid it. So everything we can do to clarify that up front, again, it feels perhaps to some, boy, all these pages, why all these pages? Every one of those pages is trying to help solve problems that people have told us about, and we're going to try to do it as best we can.
Thank you very much. Appreciate your answers. I yield back, Mr. Chairman. Thank you.
Joe.
Thank you. Thank you, Mr. Chairman. There we go. Thank you, Mr. Chairman. Mr. Cordray, welcome. We've heard recently about CFPB's examination notification process, and it's raised some questions. From what I understand, financial regulators usually will contact the entity to be examined by letter to make them aware that an examination has been planned and send that entity a pre-examination checklist. I've been told recently that CFPB has been contacting these entities and on very short notice asking them to come to Washington, D.C. and meet directly with you. Why are you calling these entities, you not yourself, but why are you calling these entities to Washington, D.C. to simply notify them of an examination? Or do I have that wrong?
To be frank, Congressman, I'm not sure where that's coming from. That's not, in fact, our practice. I am not calling people in to meet with me. Don't really see what the point of that would be.
Are people being, Mr. Cordray, are people being called to Washington to notify them of a pending examination?
No, they're not. Let me say this. We're a new agency, so when we notify someone of a pending exam, it's the first time they've ever heard from us. So what we typically try to do is set up a meet and greet, but I believe that we almost always go on site. We don't put the people out. We go there, and I don't mean me, I mean our examination staff, and meet with them and have an initial meeting. For the other agencies where typically they've been regulating and supervising and examining these people for years, they just were there 3 years ago, now they're coming again, they probably, very common that they would send a letter. We're trying to do a meeting, but we're not calling them to Washington for that.
So you don't know of any instances where you are calling people to Washington where people are having to come to Washington to be notified of an examination?
No. What we are doing is there are times when we're having people come to Washington, or if it's more convenient, we can go to them, or they may be coming to Washington anyway and want to come in to see us, where we are talking to them about specific issues of concern. But in terms of the normal examination process, no, we're not dragging people to Washington just to tell them we're going to come to see you in 3 weeks. That seems kind of stupid to me.
To simply notify them of an examination.
Yeah,
because you concur that makes no sense.
That would be pretty dumb. We're not doing that.
Okay.
Yeah.
Do you have to be present when you're notifying any small banks or mortgage companies of a pending examination?
No.
You yourself?
And in fact, I'm running an agency that's growing and is doing work all across the 50 states. I couldn't possibly do that. That wouldn't make any sense for me. That would be a very poor delegation of authority on my part.
Would the gentleman yield?
Yes, I'd be happy to.
I just would like for Mr. Cordray to correct for the record the question itself when he asked small banks are called. They are exempted.
Well, small banks, anything under $10 billion in assets, we don't even examine. So none of them would be called anywhere. But it's also not our practice to call people to Washington to inform them of an upcoming exam.
And you've made that clear. So, and yeah, I think
although there are some special issues where we need to talk to someone about a particular issue that might or might not warrant a meeting.
Okay. So banks and mortgage lenders, you've made that clear that you don't know of any instances. And again, it's not at all a requirement that you or your deputy director, Mr. Date, needs to be present or is present during any of these meetings.
Frankly, our examiners are much better equipped to manage and handle all aspects of the exams than I would be.
Thank you. I yield back, Mr. Chairman.
Thank you, Chairman and Ranking Member, for holding this hearing. Look, our economy is still reeling and recovering from what I believe was the damage that was caused by this housing crisis. And I know my small businesses, their biggest complaint is they've lost customers. So they're really concerned when folks are losing their homes and surrounding cities are contemplating bankruptcy as a result of it. So my small businesses want their customers to stay in their homes. And so I'm, for one, and grateful that you're going to be able to do anything you can to make sure that folks really understand what they're getting into when they're getting into a mortgage. You know, before even, we now know that before the housing crisis, several banks were participating in predatory lending and were in some cases blatantly targeting minorities. And we know that even after controlling for income differences, the Center for Responsible Lending found that African American and Latino borrowers were about 30% more likely to get higher rate subprime loans than white borrowers with similar risk characteristics. Can you tell me how the proposed rule will help to end this discrimination, and anything else that you can share that the CFPB is doing to protect minority borrowers from these, what I consider shameful predatory lending practices?
Quickly.
So thank you, Congresswoman. There have been, as you've probably seen, several enforcement actions in recent months taken by our fellow regulators. We work closely with them. We have now the authority to enforce the Equal Credit Opportunity Act, which will govern a lot of this kind of discrimination. We take that responsibility very seriously. We have an Office of Fair Lending in the Bureau. It's I would say at this point, superbly staffed by high-quality people who are very dedicated to this work. We're working closely with the Department of Justice as well, and there are times where we will coordinate with them on actions, and we're working with State Attorneys General where that's appropriate. But we feel that everybody in the United States is entitled to access credit on the same terms as one another, should certainly not be affected by gender or by race or by ethnic background. Too often that has occurred in the past. The laws are now meant to prevent that. They have to be enforced effectively if we're going to accomplish that. That's part of our mission.
Thank you. With that, and I don't want to keep you, so I'm going to ask the members that have questions, I've included myself, to submit them to you and get and in fact, my question is just about that. You said in your statement that the panels are a very valuable component of our rulemaking process, and I'm very curious as to if you think that other federal agencies should incorporate the panel process into their rulemaking. And I'd like an answer. Just submit it back. You don't have to answer now, but I want an honest answer.
Yeah, we'll be happy to address anything anybody wants to submit to us in writing, Mr. Chairman.
And that way we don't have to keep you. I know you're very busy, Director. This committee is going to continue to be very active in watching how you move through the Reg Flex Act.
I'm at your service anytime.
We appreciate it. And in fact, and I would ask unanimous consent too before I finish with the ranking member. Unanimous consent that we have 10 legislative days for members to support materials and questions, whatever the case may be. And
yes,
without objection, so ordered. Go ahead.
Thank you, Mr. Chairman. Two questions. Can you state for the record how much did the housing collapse cost this nation?
It was trillions of dollars in household wealth, let alone trying to assess people who lost jobs and how much the downturn affected our broader economy.
Okay. And I am interested in knowing when the agency is going to comply with Section 1071 that is aimed at helping regulators understand credit conditions for small women-owned businesses and minority-owned businesses. It is important that you implement the rule requiring the collection of that data.
Yes, we're mindful of that. We also, as you may know, we have a separate window on this through our Office of Minority and Women Inclusion, and that gives us some ability to work with the financial industry on diversity in the financial industry, which we take seriously as well. So I think all those things fit together.
Thank you, Mr. Chairman.
Again, thank you very much,
Thank you.
Director Cordray. We appreciate you coming in. With that, hearing's adjourned.